So next panel is about safety and just culture. And as Donatella mentioned before, the Netherlands are privileged to have a dedicated aviation prosecutor, and we are more privileged and honored to have Katja van, I'm very bad with Dutch surname, Bijsterveldt, who is the aviation prosecutor in Amsterdam. Katja, please. The floor is yours.
Thank you, Laura. It's a privilege for me to be here. Context, trust and transparency and legal certainty are the key words for me as a prosecutor in the Netherlands. I gave a lot of presentations with my colleague, and most of the time they are 1 hour or so I'll try my best to put it in 8 minutes. For 6 years now, I'm the aviation prosecutor of the Netherlands. And the first one was established or appointed 41 years ago. That's a long time. So I'm absolutely not the first. Here's some of my successors on a picture. The first one was appointed after a signal of our aviation police. We have an aviation police that's very terrific to have that. And the aviation police was established in 1953. And they brought a signal to the public prosecutor service that they saw different approaches in the Netherlands by the prosecutors at aviation cases. So they pointed out, isn't it possible to have one aviation prosecutor for the whole of the Netherlands? Yeah, we listened to that, and in 1984, the first prosecutor was assigned. And now I'm the prosecutor for 6 years, as I told. The aviation police is a group of people, all men at this moment, and they are very experienced in aviation cases. They are very experienced in the regulations. They can put in files in a way that we, judges and prosecutors, can understand it. That's very important. Also for the lawyers involved, it's very useful. And they all are educated to investigate all the aviation incidents, occurrences, crashes, etc. And they are all have all a permit to fly, and that's also a pro when you are talking to people in aviation that are have just had an occurrence with his or her plane. The great benefit of one aviation prosecutor is that the approach of all the aviation cases in the Netherlands is the same. Of course, we look at facts and the circumstances, but when it's quite similar, the approach will be similar. Last year, January 24, we established, not too fast, expertise center for aviation at our public prosecution service. And we doubled. I was with one other guy, Ako Verhaag, a guy, it's not the way I had to talk about him. He is working on his PhD on just culture right now, and I think he will end it in a month or so. And he's my policy advisor and my clerk. So we are with both. We are handling all the aviation cases, but we want to professionalize our way of working, also for our successors. And we want to capture our knowledge, and we want to be transparent. So, and another important issue was the increase of the drones. So we want to make it more professionalized. So I asked for 2 more people. I now have a substitute prosecutor in our club, and another policy advisor, especially for drones. And now that's very useful with the NATO coming up next month. A very important thing, transparency, is that we have a website, and I show at the last slide where you can find it, and there we all publish all our decisions. A lot of our decisions end up in a dismissal, and no one hears about it, but we publish them all because we write large letters with all the motivations why we come to that decision, and so everyone in the aviation field can read it. We are a bit behind in the English version, but in Dutch we are really accurate at this moment. We try to make it complete this year. I'm also a member of the Just Culture Task Force. That's a club of the Eurocontrol since a lot of years, and I'm also a co-organizer of the Prosecutor Expert course, also with Eurocontrol, and there we have each half year a course for all people in aviation, judiciary, pilots, ATCers, and other, sometimes of judges. And it's very useful to spread out the word of the Just Culture and how to use it in aviation cases. The Just Culture Road in the Netherlands was a bit bumpy. We had some major events. We had the Delta incident, Transavia tail strike, and the Turkish Airlines crash, of course. And in these cases were prosecutors involved. But it helped us to build the way we work in aviation cases also. And on the Turkish Airlines case, I will be back later on. Just Culture is a legal concept with a background in safety science. And the EU regulation 376 from 2014 is the basis of that. It's about occurrence reporting to the CAA, but also about protecting these reports. And there's a preamble, 36, sorry, where it's all written out, and you can read it on the screen. But it says the civil aviation system should promote a safety culture, facilitating the spontaneous reporting of occurrences. Just Culture is an essential element of a broader safety culture, which forms the basis of a robust safety management system. And an environment embracing safety culture principles should not prevent action being taken where necessary to maintain or improve the level of aviation safety. So this preamble shows that Just Culture should be seen in the context of promoting a culture of safety. And actually in a way, as James Reason put it forward a long time ago. A Just Culture can make people dare to report, and if people dare to do so, organizations are informed. And so organizations can learn. And then it comes down to the organizations being flexible to take the right action. And being flexible also means that you have to be flexible in the attitude towards deviant behavior, And you have to be fair about it, and that creates trust and certainty. Nope. It's not a blame culture, the Just Culture, how it's described in 376, like it was called in the past. Gross negligence and intent are not tolerated. And experience and training are very important to look at that case. In 376, it was not meant for the criminal cases. It was assigned to each country of the EU to take it into account in their own country and regulate it. And that has been done in the Netherlands. And the big question is, of course, who draws the line? If it's intent, gross negligence. That's not the safety board or the CAA. That's the prosecutor or a judge in some systems. And criminal enforcement is simply said the task of the prosecutor. Why do we need even a prosecutor in aviation cases? Criminal enforcement, that's the main task of the prosecutor. And that's on behalf of society, in the public interest, and according to the rules of law, and the position of victims be given particular attention, of course. And Peter will talk about that later on. There are many differences in Europe, different systems, and I don't have to tell you that, of course, with all these lawyers in the room. But it's important for the way you can take Just Culture into account. Sometimes it must have its effect in the courtroom. But in the Netherlands, there is an opportunity principle, a discretionary way to look at cases for a prosecutor. A prosecutor can include just culture in his deliberations. And the prosecutor can decide for himself whether to go to court or not in a case. And that's not only in the aviation cases, that's for all cases in the Netherlands. And the factors of general interest are important. Does the prosecution serve society as a whole? And we look at the seriousness of the offense. Oh, sorry.
I don't know whether you hear me. Okay. Can you hear me?
Yeah, I can hear you.
You don't need to go to the court
No.
to have a second level like we have in Italy of an independent judge?
No.
Oh,
no. In the
this is
Netherlands,
really
you decide
interesting,
as a prosecutor what to do. I decide if I will start an investigation, a criminal investigation. In some countries, you are obliged to do so. In Germany, for example, you have to start an investigation, criminal, when there is probably something criminal has been occurred. But it's possible for victims or other people to go to court after my decision not to go to court.
To challenge your
decision. They can complain about that, and then it's possible that the court says you have to go to prosecute.
Sorry for interrupting,
No.
we don't have so much time, but I was really curious because we have a completely different system, but we will discuss later on.
Okay, yeah. But the factors of general interest are important for the prosecutor. And of course, they can, what I said. In 2024, the EU Court of Justice confirmed that ensuring a high level of civil aviation through Regulation 376 is in the interest of the public. A Dutch news channel wanted to obtain occurrences reported related to the MH17, and the court ruled that the system is in the public interest. It's the system of 376. Here's the text, but I will go on. So, all interests are important, victims, society, etc. But society wants answers what happens about blame and liability. And Peter will talk about that also. We had a Bijlmer disaster in 1992. And the investigation was only 12 days. And that's ridiculous. You can investigate something like that in 12 days and say nothing went wrong. Honest answers require investigation, and honest answers require context. And we had also a very long investigation, and that was the Turkish Airlines crash. You all know what had happened at that moment. And in the end, there was a dismissal suspicion of Turkish Airlines, Boeing, and the air traffic controlling by the prosecutor of the Netherlands. But the decision was taken in 2011, so 2 years, 1.5 years after the incident. And the Dutch Safety Board had also investigated, and they ended their investigation in May 2010. So why took it so long for the prosecution decision? We had no access to the flight data recorder data. The Dutch Safety Board took it them without consultation, and they didn't want to share the information with us. So the prosecutor had to do it in another way, to find all the information and gather it in other systems to get the same information as that was in the flight data recorder. And that was nearly a year of delay. And now we have a very good contact with our safety board. Next Monday I will be with them talking about the future, etc. But we'll see when a great event happens again in the Netherlands, how it will. For us, the most important thing, I'll skip some slides, is the context. Context matters, and I'll show you a film. And there's no sound.
Fully understand what's going on.
So this says it all for us, this movie, this small movie, because context matters. It's very important for a prosecutor to know what had happened, and we would like to hear it from the persons involved. And that's also very difficult because someone has the right to remain silent, of course, but when there is a very important context, I have to know it, because otherwise I can't take it into account. So in a lot of cases, I have a hearing at our office with a suspect, but I don't want to make my decision only on paper, and sometimes it changes. I think on paper, oh, what's this? And then I talk to someone and he explains all the circumstances, and then for me it becomes a dismissal. So it's very important to know the context. And then I can take also in account, is someone reflective, and did he or she take some action in a way to talk to his own flight club or something like that. So there's growing trust in the Netherlands, transparency and legal certainty, and I think that it's very important to create flight safety. So the just culture principle is very important for the prosecution in the Netherlands. Whew. Yeah? Okay.
Since you are not only prosecutor but a lady, I took the liberty to ask to the next two men lawyers to reduce their time, because at 11:40 we need to leave the floor to the next focus. So Peter, with this word, the floor is partially yours.
Let me begin by thanking Laura for inviting me to speak on this panel. I'm very grateful to be on such a distinguished panel. I was wondering what to speak about when looking at the subject of just culture, and I thought the most interesting thing from my perspective of acting for families would be to talk about how families interact with the term just culture. So this is taken from what will be 20 years next year of acting for grieving families. It's really my perceptions of their interaction with the concepts that we're talking about today. So I guess the starting point is, do families support the concept of just culture? And I think the answer to that is, first of all, that the phrase is something that's unknown to families. It's not a common concept. It's a concept that we work with legally, but I think the meaning behind it is recognizable to them. But the route to the answer to that question is through anger and outrage and trust. And it was interesting that Katja used that term, because I think it applies equally to families, and that's a term that resonates with them. Anger and outrage comes from what they know about the accident and what they grow to understand. So in the most part, they don't think about terms like gross negligence or willful violations or destructive acts. But they do think about intention, they do think about carelessness, and they do think about how a company has responded. I think, first of all, when it comes to anger and outrage, if you look at, let's look first of all at the kind of the airline situation. And I'm predominantly going to talk from an English perspective here, and I know that there are jurisdictions like France where this becomes more complicated, and I think Gregory will probably expand upon that. But from an English perspective, if it's well managed, there's no reason why families need to get to anger and outrage against an airline. They're excluded from the investigation, the Annex 13 investigation. In the UK, the AIB is excellent at managing their information and keeping them updated. The actual investigation report is obviously written in a language which doesn't include, doesn't apportion blame or liability. In England, there'll be the dual investigations. There'll be a police investigation that is undertaken at the same time, but more often than not, there isn't some criminal liability behind, and that police investigation does close down. So there isn't the information that comes out through the media that kind of incenses them. I think that as their lawyers, it's not necessarily in their interest for me to go hunting around to try and find criminal liability. There could be insurance implications for that. And that, together with a strict liability regime under the Montreal Convention for these cases, means that unless they start arguing, the airline starts arguing that there's some kind of limitation of liability under that convention, then we can actually make our way through that process with the families actually just understanding that it was an accident and not seeking some kind of retribution. Of course, if there is clear evidence of willful violations or intention, then the families want those perpetrators punished. But that's in line with the just culture policy, so I don't think there's any difficulty there. I think perhaps where the tension exists is in relation to gross negligence, in circumstances where there's maybe no strict liability regime or there's punitive damages on offer. As a lawyer acting for families, there could be good reasons for me to start to explore and dig in those circumstances. There's no commonly agreed definition of gross negligence, but I think the roots to gross negligence might be said to take us through negligence in determining that standard of care, and then in terms of the breach into the kind of the depths of how poor that actual breach was. So for a litigator, that's a path and a target, and we're going to follow it. And if it leads to evidence of gross negligence or worse, then so be it. And my job is purely to bring that evidence to light, but I recognize that in doing so, it does invoke anger and outrage amongst those family members. But I think from my perspective, the core framework for just culture to succeed requires aviation enterprises to do two things. The first part of this kind of just culture phrase is that they should properly deal with these minor negligence actions by investigating, changing processes, improving safety. But that is a process that happens behind closed doors. It's a responsibility given to aviation enterprises to complete that process successfully. The second part of this is that they should not tolerate instances of gross negligence, willful violations, or destructive acts. And that's an acceptance of a process that's acted out in public through the prosecution. So for families, if B is not followed, then they can't trust the company to do A. So I just want now to just give two examples very briefly of where I think it's gone right and where I think it's gone wrong. The first example is the Shoreham Airshow disaster. You can see the catastrophe in the background of this. This was a 22nd of August 2015, a bright sunny summer's day. A Hawker Hunter was performing an aerobatic display. It crashed on the A27 Shoreham bypass, killing 11, injuring 13, including the pilot, Mr. Hill. So my firm acted for families of those killed and the vast majority of those injured. There was an AIB investigation that was commenced alongside a criminal investigation by the Sussex Police. The AIB investigation concluded and the inquest commenced, and partway through that inquest process, the Sussex Police announced that they had charged Mr. Hill with 11 counts of gross negligence manslaughter. The inquest process was stopped and the criminal process continued. After an 8-week trial, a jury unanimously acquitted Mr. Hill of 11 charges of gross negligence manslaughter. Of course, for the families, that outcome was extremely upsetting. The inquest resumed and the coroner concluded that the death of those 11 individuals was caused by unlawful killing. And the reason for that conflict is because of the different standard of proof in the inquest versus the criminal process. Following the inquest in October 2024, Mr. Hill applied to have his license reinstated. The CAA refused, and Mr. Hill took them to court, and a few weeks ago, the High Court affirmed the CAA decision. So in my opinion, this is a perfect example of just culture correctly applied. The actions of gross negligence were not tolerated by 3 separate processes, and it doesn't matter that ultimately Mr. Hill was acquitted. The process was followed correctly. The second example is the Boeing 737 MAX saga. So on 29th of October 2018, 189 passengers and crew lost their lives on board Lion Air Flight 610. 6 months later, a further 157 people lost their lives on board Ethiopian Airlines 302. I've really only included the Ethiopian Airlines investigation here because that was what triggered a lot of what followed. The safety investigation was underway. While that was underway, there was a parallel investigation undertaken by the Department of Transport Office of Inspector and the FBI. And on 7th of January 2021, as our news channels were flooded with images of violence in the capital, the Department of Justice quietly announced that they'd entered a deferred prosecution agreement with Boeing to resolve criminal charges relating to a conspiracy to defraud the FAA Aircraft Evaluation Group for a sum of $2.5 billion. In May 2024, the Justice Department concluded that Boeing had breached the deferred prosecution agreement, and I will rush on. But ultimately, in December 2024, following a further agreement to plead guilty, the Judge O'Connor stated that Boeing's crime may rightfully be viewed as the deadliest corporate crime in history, and stated that he rejected the plea agreement. Finally, in March 2025, after a change in administration, Boeing negotiated with the Justice Department to enter into a non-prosecution agreement in exchange for a payment of $1.1 billion. No one will face prison time, no one will have a criminal record. This is 4 weeks before they were meant to commence the trial. Now, as a kind of concluding remarks on this, so irrespective of the US Department of Justice or Boeing's motives, this decision to drop any criminal prosecution in exchange for money, it looks like money and power enables companies to sidestep criminal accountability. The optics of it is, in my opinion, all wrong. It does not look like criminal actions being not tolerated. It doesn't look like just culture. At the outset, I asked, do families support the concept of just culture? And you might say it doesn't matter, but for me, what the reason it matters is about public outcry. Public outcry is the enemy of an effective just culture process, and anger, outrage, and a loss of trust, it leads to this public outcry for families. So in my humble opinion, it shouldn't just be families calling for full prosecution of Boeing managers in the deadliest corporate crime in US history. It should be everyone in aviation who believes in just culture. Thank you.
And now I am between my friend Gregory and my friend Mia, so I will ask not to abuse, because we have to leave the floor to Mia and Linda. So, having said so, please.
Well, the good thing being the last to speak in the panel that you can scrap most of what you prepared because I already addressed it. And basically what you said was very interesting for me, so I would change most of my presentation and just discuss. And also, I was a bit surprised by your presentation as a plaintiff's lawyer, because I will be a bit more aggressive against just culture than you were. Even if I'm an airlines lawyer, working a lot against manufacturers, so it's maybe why. As you say, just culture is, and you are very clear about that, is honest mistakes from staff should not be punished, basically. My view is that it's a very important, it's a cornerstone concept of aviation law, of aviation more broadly. It is quite a limited concept. It's a limited concept, maybe not in the Netherlands, from what I understand, because you, as a prosecutor, take it into account. But it's a limited concept to labor law or regulatory fines, etc. And the whole question is, when you actually come to liability, whether civil or criminal, is this concept still important? Is this concept still there? And is this concept, should this concept be included in the context of civil liability or criminal liability, or should it not be included? Because if it creates some unaccountability, it maybe the whole purpose of just culture just falls down. Because if people are not liable at the end of the day, whether civilly or criminally, maybe they don't feel that they have to report, or they don't feel they have to do their work properly. I know that you would say probably, yes, they did, but I'm a bit pessimistic on that. So when you come to civil liability, for example, I think there is a difference between airlines and manufacturers when it comes to just culture. Airlines, they are subject to the Montreal Convention, as you said, and basically whether just culture or not, you don't care on civil liability. Airlines pays up to the limit of the Montreal Convention or not. This is another debate. When it comes to the manufacturer, it's quite different because manufacturers, well, when you think about a major loss, you have to think globally. You have many nationalities, you could have a lot of jurisdictions involved, like if you take Air France 447, it was 32 nationalities, 18 jurisdictions involved with 18 different laws applicable to the claims, depending where you are. And all these jurisdictions, unfortunately, some of them just don't know the concepts of just culture, the judges, civil judges. But as a manufacturer, your product liability, you can have a strict regime like in Europe with some defenses, you can have a tort liability, etc. And this is where the just culture finds its limits, I think, in terms of civil liability. Because can a manufacturer say, okay, well, I'm not liable because there is no gross negligence or there is no willful misconduct? Maybe in the relationship between the airline and the manufacturer that would be dealt with in the contracts, but with regard to the plaintiffs, I am not sure it should be the case. I think it's something else. And when you now come to criminal liability, I think it's even worse. And I was very interested about what you said about the UK and the fact that it very rarely end up into criminal investigation or criminal trial. In France, any major loss or every time you have a death in an aircraft, you can be sure like 90% of the time you end up with a criminal trial, whether it's a major loss or a small loss. And in Italy, my recent experience is quite, it's the same, and it's even worse, I would say. And criminal liability in France is very easy to find. You don't need to have gross negligence. You don't need to have actually infringed some regulation. You just need to have been careless, imprudent, or just negligence, and you fall. You can be convicted of manslaughter, involuntary manslaughter. And my experience in France for the Yemenia crash, for the Air France 447, and for many others, except the WCA one, which is a bit different, but for all these major losses, plaintiffs' lawyers, they go straight to the criminal court. Because when you go to the criminal court as a plaintiff lawyer, for the airline or for the manufacturer, it's much more important than civil liability, which is insured. They don't care, basically. And so you are more likely to settle. And you are more likely to settle at higher amounts. And this is why now in France, we have criminal cases in the Air France 447, so the appeal will take place in November, October, November. The Yemenia crash, the appeal took place last year. And when you come back to just culture, I think, frankly, the judges don't even know the concept. They do not care about the concept. And it's a huge difference between France, and I'm speaking about France, but maybe Italy and a lot of other countries. The public prosecutor in France for the Air France 447 and for the Yemenia crash was a terrorism judge, public prosecutor. So no experience at all. It was his first aviation case. The judge, the president of the Court of Appeal, was hearing the case in the Yemenia crash. She used to be a judge for small burglaries or this kind of stuff, okay? She had no experience. Well, she did once a car accident, okay? And no experience at all, okay? And she was there with the Yemenia crash. And she will be the same one doing the Air France 447 crash, okay? Based on her experience on the Yemenia crash, which honestly is not a great result for her, but anyway. And just culture is out of her mind. She doesn't care. It's criminal liability. And I know that I need to be short. For me, and I think it's very important for everyone in the room to think about it, that just culture is okay, it's at ICAO level, it's EU level, etc. But at the end of the day, if you're a manufacturer, if you're an airline, and you want to rely on just culture, forget it in most of the regions of the world. That just won't happen. That just won't happen. And just culture is important, but at the end of the day, liability will prevail over just culture. Whether it's good or not for safety, I'll leave it to you to think about it. My views is that it is, because accountability liability is a much stronger element for safety than just culture. That doesn't mean just culture is not important, but only on a very strict, limited basis. Thank you.
Thank you, Gregory, and I guess we could continue for hours to discuss about just culture, different regime, but we need to leave the floor to the next focus.